Hello, everyone. Again, thank you for tuning into today's on-demand webinar. This is Breaking Down Brexit Part 2. We recorded Part 1 back in December of 2020, which was a month ago, before we had an official trade deal. Now we're back in January, updating all of the information you got in Part 1 following the UK-EU Trade and Cooperation Agreement. Again, I am pleased to be joined today by Stefan Nerinckx as he walks us through the TCA through the lens of HR and recruitment. Over to you, Stefan.
Thank you, Carolyn, for this nice introduction. I'm a partner at Fieldfisher, a partner in the Employment Law Department in the Brussels office. And I have been practicing employment law now for 30 years nearly, and also specializing in international mobility. So indeed, when we last spoke in my first intervention, that was on the 18th of December, little did we know that a few days later, a trade and cooperation agreement would be signed. And I was referring to it in my first presentation that if there would be a TCA, that it would not have a major impact. And that is certainly true, although some aspects have been regulated in that TCA. And that's what we are going to focus on today. So for you not to go back and forth between the first presentation and the second presentation, this one, I have reproduced the major items that I discussed last time, and I will focus then on the new items, new issues, which have been regulated by the TCA. So indeed, here you see the timeline of the Brexit, and the green here on my slide was not there yet on the 18th of December. And today it is done. So indeed, as from the 1st of January 2021, the TCA, the Trade and Cooperation Agreement, regulates the relation between the EU and the UK. Mind you, EU, so Liechtenstein, Iceland, and Norway are not included in this TCA. And in a relation between those countries, EFTA countries, well, national legislation will prevail, not this agreement. So as from the 1st of January 2021, after the period which was regulated by the withdrawal agreement, that was 2020, a new era starts with this TCA. Now, in immigration, residence and right to work, in respect of immigration, as I was saying last time, as from the 1st of January 2021, EU countries vis-à-vis the UK and vice versa are to be looked upon as third countries. That means that the citizens are third country nationals. And that includes that whenever you send someone from the UK to one of the member states of the EU, national legislation in those EU countries will be applicable in respect with immigration. Work permits, single permit, residence legislation will be national. That means that if you send someone to France, this might be different than sending someone to Belgium, Holland, and so on. Every single national state in the EU has its own immigration legislation. Although quite inspired by European legislation, yet different. Now, I was saying last time, and to recap on that, that whenever a UK citizen comes to the EU and was already legally residing or was a frontier worker, meaning that, for instance, he lived in the UK but worked in Belgium, well, that status can continue, meaning that the status was regulated by the withdrawal agreement, and that status will continue as long as the situation doesn't change. The situation of the person doesn't change. Doesn't change employer, for instance, was seconded, will now be hired by a Belgian company, for instance. That are changes which will put an end to the situation regulated by the withdrawal agreement. But if the UK citizen was legally residing, working in Belgium, this can continue if the employee, if the person complies with the necessary registrations at the local authorities in the country he will reside and he will work. A special permit will be delivered, and in most countries, the person will have until the 30th of June 2021. In Belgium, for instance, 31st of December 2021 to regularize the situation regulated by the withdrawal agreement. So this is working, residing before the 1st of January 2021 in one of the EU countries. After that, when you start on the 1st of January 2021, UK citizens wishing to reside and to work in an EU member state will be considered as third country nationals, will have either to apply for a work permit, a visa, a residence permit, so they will have to comply with the immigration legislation. And again, if the situation was regulated by the withdrawal agreement, they will have to comply with the registration obligations in the country where they work and reside. From a UK perspective, also the end of free movement on the 31st of December 2020 and EU nationals already residing, working, and I'm not going to go into details, but that was, I detailed that in my previous presentation. Well, they can qualify for the settlement status. Settlement status is like the withdrawal status, the withdrawal agreement status, and this status will give them the possibility to still continue to work and to reside in the United Kingdom if they comply with the settlement status requirements, they register, and they have, or they can demonstrate the number of years that they have been, or the number of months, periods they have been residing, working in the United Kingdom. If not, then they will have to apply for a work permit in the United Kingdom, look for a sponsorship, apply for the points-based work permit in the United Kingdom, as if vice versa also a UK citizen will have to do in the EU when working and residing in the European Union. And of course, there to regularize the situation of the withdrawal agreement, citizens will have until the 30th of June 2021. Now, the TCA doesn't really address immigration issues, but some aspects have been not altered, not changed, but certainly in respect of business trip definition, as I was mentioning in my last presentation, every national state has its own description, definition of a business trip. It can be quite extensive or quite limited. The UK has a quite extensive interpretation of business trip. Now, the TCA also gives a very broad interpretation of what is deemed to be a business trip. And in fact, to give you a few examples, we are talking about sales representatives, we are talking about fair trades, we are talking about coaching, we are talking about commercial transactions, we are talking about after sales, tourism, translation services. All these would be incorporated or would be considered as being a business trip. Now, the question, of course, raises whether the EU member states will follow the interpretation that has been given by the TCA. It's not compulsory, it's more like a definition given by the TCA, but of course, as I said, national legislation will have to apply. So national legislation will have to be changed, will have to be adapted if the national legislator wants it in respect of the TCA broad interpretation. And it might also be that not all the items that I listed, and this is not exhaustive, but all the items that I have listed, which were listed by the TCA as in the definition of business trip, well, that all these are being taken over by the national legislator. It might be that the national legislator takes over one or two out of other states 7 or 8. So this is to be looked upon on a case-by-case basis whenever you send someone out to from the United Kingdom to the EU. In the other direction, as I stated or in my previous presentation, the business trip definition is already quite broader than in most European Union states. One aspect also which has to be underlined in respect of those business trips, besides the fact that the interpretation can differ, what is not to be different is that whenever a UK citizen comes to the EU, he will be able to move freely in a period of 90 days within a 180-day period. When a EU citizen will enter into the UK, he will be able to freely move for a 6-month period. What do I mean by freely move? It meaning that the person will not need a visa to be able to go into the UK or into the EU for a limited, whenever he spends a limited period of time within a certain frame of time in one of the countries. Another aspect is the intra-company transfer, which will also continue to exist between the UK, between the EU. It means, what does it mean? It means that whenever a company, a UK company, sends someone out to France, and that French company would like to send for a temporary period that UK citizen to Belgium to perform a specialized job or to have a special management role, or eventually even the person is a graduate trainee, well, in that case, the work permit requirements and the work permit being delivered by the French authorities will also be valid for the UK citizen when working in that intra-company transfer perspective in Belgium. So that means that that also will apply to UK citizens as from the 1st of January 2021. And the residents are already mentioned. So in essence, nothing new with the TCA, but we might expect some new regulations in respect of business trips. Business trips, which I commented on last time, if we look into some surveys looking into the future of international mobility, well, business trips together with teleworking, so the virtual assignment, will certainly gain some importance. So the business trip is certainly an aspect to be looked after also in the future. Now, the item where the TCA brings quite some changes to my previous presentation is in respect of Social Security coordination, Social Security benefit coordination. And this is all to the benefit of the UK citizens and the EU citizens. Remember, in my first presentation, I said, well, national legislation will prevail. Well, this, in fact, is no longer the case. Let's have a recap. Whenever you travel within the European Union and traveled within the European Union for UK citizens, international mobility and the applicable social security was coordinated by regulations on a European level. It doesn't mean that social security was harmonized so that we all had the same social security system. Each country has still its own social security system, but whenever mobile within the European Union, the systems are coordinated, leading to the fact that only one social security scheme is applicable at the same time. So that, in fact, at the end of or during an international mobility assignment, you are not subject to different and to multiple social security schemes, which makes it quite complex and which would also be quite a limitation on international mobility. So this is not the case. Every state remains or keeps its own social security scheme, but they are coordinated to have only one scheme applicable in case of international mobility. So this applied for all the UK and the EU citizens until the 31st of December 2020. And in fact, the individuals concerned were absolutely urged to ask for the E1 document, other eventually evidence documents that they were subject to that social security scheme within the European Union, within one of the member states of the European Union. Now, as from the 1st of January 2021, as I said, before the 24th of December, it was every national legislation that would have prevailed, meaning that you would have to look what the relationship would be between the UK and France, the UK, Belgium, the UK, Holland, etc. Well, this is no longer the case, and it makes things way more easier than explained in my previous presentation. So the situation present before the 1st of January 2021. So situations regulated by the withdrawal agreement. Well, in this case, as long as the situation doesn't change, meaning that the person is still being assigned, seconded from the UK, for instance, to France, or vice versa, that the person is assigned to the same company, for instance, well, that situation will continue even after the 1st of January 2021. So it is regulated by the withdrawal agreement, and there is no change in the situation, factual situation, legal situation, that regulation or that scheme will continue to exist even after the 1st of January 2021. It's still unclear in respect of posting, because we will see that posting is now limited to 24 months, UK, EU, EU, UK. It's not clear yet whether if a posting was being granted for 5 years maximum on the basis of Article 16 of that EU regulation, which whether this will still be continuing and that the 5 years will be, that the employee will be able to end the 5 years, even if some years or 3 or 4 years have still to be complied with after the 1st of January 2021. So the question is whether the UK authorities will take into account the 5-year secondment to continue, because the situation was already existent before the 1st of January 2021, or whether they will reduce the secondment to 24 months in case the employee is indeed being assigned from the European Union to the UK. That is still a question, and probably some other open questions remain still to be looked after between the respective administrative authorities. But in essence, the regulation still applied on these situations. Now, as from the 1st of January 2021, a new cross-border employment situation, or there was an interruption of the existing employment or international employment situation, well, then the TCA will apply, or the regulations of the TCA will apply. And that means that whomever has a legal residence in the EU and the situation was not ruled with the withdrawal or by the withdrawal agreement, well, then the rules of Regulation 883/2004 will apply. I correct myself. It is not as such the regulation which will be applicable, but in 95% of the regulations put forward in the TCA are a mirror of the Regulation 883/2004. So it's not the regulation itself, but the rules written down in the TCA are 95% comparable with those in the Regulation 883/2004. So they have been copied to a large extent, but have been rewritten and written down again with some changes. And we will come to that in a second. What are the changes? Well, the changes, or one of the first changes, major changes, is in posting of the employees. Posting, meaning that the employee can remain under certain circumstances subject to the social security scheme of the home country. The employee is being assigned, remains employed by the home company, but is being assigned for a period of time to another country, to another company in that other country, and can remain subject to the home social security during that time. Now, the Regulation 883/2004 provides for a 24-month posting assignment in respect of social security. But there was, and there is still, within the European Union, an exception, an Article 16, which makes it possible to extend the period beyond the 24 months to a maximum of 5 years. So the posting could be extended after the 24 months to a maximum of 5 years. Now, that Article 16 is a broader article. It is an exception article, meaning that the authorities of 2 states within the European Union can come together where there is an issue and they have to take an administrative decision. So it's not only with posting, it can also for other issues. Well, that article is not taken over in the TCA. It means that from a posting perspective, the assignment or the secondment or the posting will not be extended beyond the 24 months, and the 24 months will be the maximum of posting. There will not be a possible sitting together of the administrations deciding that a posting in a specific situation, concerns a specific employee, that is extended beyond the 24 months. That will not be possible. So that's the first exception or change. And I'm trying to get to my next slide, which now works. Simultaneous employment, well, there, in fact, it is a transcript of what is in the EU Regulation 883/2004. So whenever you have a simultaneous employment on the territory of different states, the EU, UK, for instance, France and UK simultaneously working, well, in that case, the regulation will apply and will only determine one legislation to be applicable. So for instance, if someone resides and works in the United Kingdom, works at least 25% in the United Kingdom, well, works also in France, commutes eventually, well, that person will be subject to the UK Social Security for the entirety of his employment relationship. And I'm talking here about salaried worker in France and in the UK, residing in the UK, 25% performing activities at least in the UK, that person will be for the entirety of the salaried worker remuneration subject to the UK Social Security scheme. And other regulations, of course, other rules apply whenever it becomes more complex, even when self-employed come together with employee, etc. It would lead us too far to go into detail with all these scenarios. In respect of Social Security benefits, the TCA certainly brought some comfort and legal security. For situations which existed during the transitional period regulated by the withdrawal agreement, nothing changes. The aggregation of periods continues and people will still be covered even after the 31st of December 2020 for Social Security benefits as they were before that date. For new situations or interrupted situations, situations which existed but which are interrupted as from the 1st of January 2021, the aggregation of periods continues, but with some exceptions, family and long-term care benefits are being excluded from coordination, and family allowances and invalidity benefits are being excluded from export. But for the commuter, going with the Eurostar from the UK to France, Paris, or Brussels, well, nothing changes. He or she will still be able to use the Social Security card for health coverage, for medical assistance in France or in Belgium, for instance, in any other EU member state, and vice versa, going to the UK, being assisted by the NHS, the European citizen, the EU citizen, will still be able to use the Social Security card to get medical assistance from the NHS. Not for private, because there are some quite differences. The only thing which will change is that the European Social Security card for UK citizens will be without the stars. That's all. So, as a summary on Social Security coverage, well, first, certainly, if the situation is regulated by the withdrawal agreement, make sure your employees, you as an employer, have a copy of all the documents evidencing that the situation existed before the 31st of December 2020. For new situations, make sure to think about the Social Security coverage, what is being covered, what is not being covered, and assess that situation. And of course, get in touch with the Social Security authorities for the proper documents. In the last section of today, I will elaborate on employment law and the TCA. And I quote what the TCA mentioned. The TCA contains provisions committing the UK and the EU to the maintenance of certain standards in relation to labor and social policy, including fundamental rights at work, fair working conditions, and employment standards. Now, ladies and gentlemen, let's interpret this. And the current EU laws after the 31st of December 2020, well, in fact, the UK government decided already in the past that there would be a body, a code for retained EU law. But what this declaration says, and what we always thought, is that the UK can modify its national legislation. They commit to safeguard a number of standards, but nevertheless, what is or what was European legislation inspired on collective dismissal, transfer of companies. These were inspired on directives of the European Union. Well, that legislation implemented in national UK legislation might change, and the UK legislator can change it. Of course, new laws will not be applicable within the UK. They will not be imported unless the UK legislator copies them or, with some changes, will implement them into the national UK legislation, but it would be, I would say, by coincidence. There is absolutely no obligation anymore for the UK to implement EU legislation. So what might change? Well, we might indeed see some legislation become less protective for workers. Areas that, when I talk to my colleagues in the UK, might be impacted by the Brexit, not the TCA, but by the Brexit, dismissal protection, harmonization of certain aspects of employment conditions following a transfer of undertaking. Working time, 48 hours of a week, maximum working time from a European perspective. And when you have read the newspapers, it was certainly some newspapers in the EU, well, this will be the first test, because the UK government already announced that they would work on this working time 48 hours a week. It will be a first test to see how far the UK legislator will go to remain in line with the TCA, not to change the standards of employment, and on the other hand, have some sovereignty about working time legislation. So that's a very, or might be a very interesting test in the weeks to come. interim workers, protections in that sense that freelance workers, interim workers, while working, might be way more flexible after the Brexit in the United Kingdom. What about cross-border mobility? Because whenever you are in the European Union and you are traveling around during your work, there is again a EU regulation which will coordinate the applicable law on the employment contract. So whenever you are working in different countries, one regulation will determine the law applicable to the employment contract, just to avoid that multiple legislation would be applicable on one employment contract, making things quite more difficult. Well, for the time being, there would not be any changes. There was the EU-UK Act of the 29th of March 2019, which reproduces, in fact, the EU regulation in respect of coordination of applicable law. Nevertheless, it might also be changed in the future. Let's see how it works from an international mobility perspective. Whenever parties, employees, employees work in different countries, there is a multiple employment, or for instance, one is employed by one employer in one country, but is assigned, seconded, posted to another country to perform a job. What legislation will then be applicable? Well, the regulation has quite a certain checklist to comply with to determine which legislation will be applicable. First of all, parties may choose the legislation applicable to the employment contract. If they haven't chosen that, it will be the country of habitual performance of the work. Or if that cannot be determined, it will be the country where the person was hired. For instance, you have a cross or a simultaneous employment 50-50 in France and in Belgium. There is no habitual employment because it's 50-50. Well, in that case, it will be the country where the employee was hired, which will determine the applicable legislation to the contract. Or what also might be the applicable legislation is the contract or the country, the law of the country where the person has the closest link with. And that's on the same level as habitual performance or habitual employment. Now, there are a few exceptions on this rule in respect of posting, for instance. In respect of posting, well, the employee will be habitually or will be considered habitually employed in the country where the employee has its home country base, home employer's base. And although the person is being seconded to another country, posted for a number of years, he will or she will still be considered ruled by the legislation of the home country when a certain number of conditions are being performed. Now, if the legislation has been chosen by the parties to be applicable on the employment contract, even then the checklist will have to be complied with, in that sense that even if a law has been chosen, the imperative legislation which would normally have been applicable if no choice would have been made will prevail if it is more protective to the employee. So whenever a choice has been made, the employer will still have to look for the legislation of the country where there is the habitual execution of the employment contract, and whether that provides for some imperative legislation which is more protective than the legislation which has been chosen, well, then that legislation will prevail over the chosen legislation. Let me give you a few examples to end. So whenever an employee is permanently hired in Belgium, well, it is not very difficult. He's hired from the United Kingdom. There is that cross-border element. He's a UK citizen, for instance. But Belgian law will prevail because the person is permanently hired in Belgium and will probably execute habitually his employment on the Belgian territory in my example. It might be useful just to look into those contracts, because You know, we quite refer a lot to the EU in those employment contracts, especially when the contract is also for a person who might have to travel in the European Union. So, like for instance, a non-compete clause might have been made applicable to the EU. Now, the EU included the UK before, but is not including the UK anymore. So, it might be useful to adapt the clause of the employment contract, including also, besides the EU, the UK. And to end with another example, let me go into an employment contract which is concluded before the 31st of December 2020. That employee is working and habitually in Belgium, is posted from Belgium to the United Kingdom. Well, in that respect, as I just explained, during the posting, if the employee has a return ticket during the posting, the Belgian legislation will continue to be applicable to the employment contract, even if it is executed in the United Kingdom. Well, that was at least, or that is, the situation when the Rome 1 rules apply. Now, if the UK would change their legislation, it might be that even during the posting, not only the Belgian legislation continues to apply, but that also UK legislation becomes applicable, or even will prevail over the Belgian legislation, which according to the Rome 1 regulation would continue to apply, but from a UK perspective would no longer apply and UK legislation would be applicable. So not regulated yet in the TCA, absolutely not. The TCA provides for the fact that both parties, the EU and the UK, should keep minimum or should keep certain standards in respect of employment law. But since both parties are now sovereign to regulate their own legislation, changes in employment law, changes also in respect of which law will be applicable in an international mobility scheme might be certainly on the horizon in the future. So to be checked and to be assessed carefully.
Great. Thank you, Stefan. And just a quick word about Workable. Stefan has been kind enough to work with us and create this presentation from scratch to help our audience really just better understand how to navigate the situation. So thank you so much, Stefan. And here at Workable, we're an applicant tracking system and we service HR recruitment teams, hiring teams, and we know this is a very confusing situation. So thank you again for breaking this down from immigration to social security and employment law. Really appreciate this update too, now that we have some answers. Even though a lot of stuff is up in the air, this at least gives us that next step of what we need to do, what we don't need to do, and kind of what we need to wait on. So again, seriously, thank you so much for your time.
Thank you very much, Caroline, for giving me this opportunity. Thank you also the audience. And I would say don't hesitate to reach out because indeed this is very, very new. And in the next few months, years, there will certainly be evolutions. Some aspects might be revised eventually even. And certainly some aspects will be interpreted by courts, but also by administrations on both sides of the channel. So this is certainly something to be continued, and don't hesitate to reach out if you would have some questions related to it.
Definitely. Awesome. And we'll also have some guides based off of this presentation and part one live on our blog. And yes, please reach out to Stefan and Fieldfisher if you need to go deeper, as I'm sure a lot of us do as we figure this out. And hopefully we can have maybe another update in the future once some of this stuff gets ironed out. But awesome. Thank you again, and we'll see you next time.